Any mention?
No mention.
Item number 1.
This matter I am required to take instruction, my lord, whether the post that has been abolished, whether somebody else is serving there or not, my lord. But I am praying for some more time because the instruction I received is not answering this question, my lord.
This post office matter
No, Nigrin's matter, my lord.
or Nigel matter? Regarding?
But here what happened, my lord, the petitioner was serving on contract, my lord. Post was deemed abolished, my lord.
Where's the appellant?
Mr. Sinkon,
Where's he? None appears for the appellant. This is the matter after 2 weeks. Mr. Dr. N. Mozika to take further instructions in the meanwhile. Yes. To obtain further instructions in the meanwhile. Yes.
deeply.
Item number 2.
Maybe, please, Your Lordship. I need little accommodation, Your Lordship, for 3 weeks.
3 weeks. You're not well, Mr. Manda?
Not well, Your Lordship.
Yes, on the prayer of the Lord Senior Counsel for the appellant, this is matter after 3 weeks. Yes.
Obliged, deeply obliged.
Item number 3. Item number 1.
Yes, Mr. Pandey.
Lordship, this is a condemnation of delay application, Lordship.
Notice has been issued.
It has been issued,
Who's
Lordship.
appealing for the respondent?
Objection also has been filed, Lordship.
So I am appealing for respondent, the sole respondent, Your Lordship. We have filed an affidavit in opposition.
Yes. How many days did
We
it
have
take?
objection against the condonation of delay, Your Lordship. 821 days delay without any explanation, Your Lordship. There is no explanation. If Your Lordship may kindly.
Lordship,
What is the reason for delay?
Lordship, this
Where's the
was
show cause?
show cause is has already been filed, Lordship.
Yes. Not show cause, I mean objection.
They've submitted their grounds at paragraph 5 of their petition, Your Lordship.
1 second.
There is no explanation as to why there is a delay of 3 months initially, then thereafter 2 months, total 5 months. No explanation at all, Your Lordship.
Substantive delay of which period?
Lordship, initially they approached the Guwahati High Court, Your Lordship, the principal bench of the Guwahati High Court.
So minus that time will be how many days?
It will be less than 100 days, Lordship.
Then we'll condone the delay.
Lordship. And Lordship, on your Lordship already remarked in an order dated 28 August 2023 that prima facie it appears that there is a good ground for condemnation, Lordship.
Where's that?
In the last order, Lordship. Order dated 28/8/2023, Lordship.
Rose wrong from.
Legal basics. If says to choose the reform, then period should be exempted. Should not be condoned. The section 14 comes.
Yes, yes.
So if it is section 14, then delay cannot be 821 days.
Yes, anything else to say, Mr. Borpuzari?
I'm P.K. Sharma, Your Lordship, and that is the one of the main reasons that I have challenged the condonation of delay is that there is no ground, specific ground as to why there was a delay, and moreover, approaching wrong forum cannot be a ground
Yes.
for
What
delay,
about
Your
the
Lordship.
application of limitation, Section 14 Limitation Act? How many
Yes,
days
Your
did you wait before the Guwahati High Court?
Less than 3 months, Lordship. As soon as the order was passed, we received it on 28th April 2023, and then this appeal was filed on
You received
July,
the order on?
28th July, Lordship.
Received the order on?
27th April, Lordship. 27th
23.
27th April 2023,
Did you
Lordship.
file your appeal before Guwahati High Court on?
Guwahati High Court, Lordship. Actually, this is order appeal against order dated 18/11/2020, Lordship. This was
1811.
11/2020, the original order passed by appellate tribunal, Lordship, and then limitation for filing was with 27th April 2021, and we had filed the appeal well within time, Lordship. There was no delay.
Okay.
Then,
We approached Guwahati High Court on 26/4/2021.
1 day before.
1 day before, Lordship.
Okay, and
One
then?
day before.
At this, on 27/4/2023, Lordship, Guwahati High Court had dismissed the appeal on withdrawal, Lordship. With, if I may be allowed to read the order, Lordship. Heard Mr. So and so, learned counsel appearing for the appellant in Lordship, Annexure 9 of condemnation application, Lordship.
Yes.
The appeal is preferred under Section 260 of the Income Tax Act 1961 against the order dated 18/11/2020 passed by the Income Tax Appellate Tribunal Guwahati in this Lordship. For the
So
assessment
just
number,
give the time that you spent before Guwahati High Court, and after that when you came before here. We will take into consideration that time. Because the way you've crafted the application, so it's not really
Lordship.
clear.
Lordship.
So for the time that you've wasted, I mean you filed within time, the first appeal, that means for the time that you spend there, that should be deducted actually.
Deducted
So
under Section
should have been-
14, Lordship.
Your application has been styled in such a manner where that comes out really clearly. That actual delay will be the delay which is, for what I just explained the previous period.
Lordship, the order was passed by Honorable Guwahati High Court on 28th February 2023, Lordship.
Yes.
We had received it on 28th April 2023, and then we had filed this instant appeal on 28th July 2023, Lordship.
Take down, seen the, there's an application under Section 5 of the Limitation Act for condonation of delay of 821 days. Stop, an objection to the application for condemnations also been filed on behalf of the respondent. The applicant in para 8 and 9 of the application has set out the grounds for delay. Stop. I'm not saying anything. He said the sufficient cause being made out with regard to the delay. So accordingly, the delay is condoned and the appeal shall be taken up consideration. Yes.
If you say some period to be exempted, can it be condoned under Section 5? Can you say, supposing if you contend that this period should be exempted, the period which you have spent before the wrong forum, can it be condoned under Section 5?
It covers under section
There are two
section
things.
14 Lordship.
One is seeking condemnation of delay, and one is saying that that period should be exempted. Two different things. Be mindful of that.
Lordship, Lordship.
You basically, your explanation in
There
paragraph
is
8 is
something wrong.
basically composition.
Yes.
Duly noted, Lordship. Highly obliged, Lordship.
Now it should be styled differently, your application.
Lordship.
But date may be fixed. Problem is it?
Yes.
May it please, Your Lordship. I beg to mention item number 32 to 38 of the hearing list, my lords. These are the appeals, land acquisition appeals. I regret to say, my lords, the paper book is yet to be drawn up. Maybe granted about 4 weeks' time as a final opportunity.
Lordship, it's not 4 weeks, let it be 2 weeks because
2 weeks may not be sufficient, my lords, because we've applied for certified copies
32
of the record.
30.
32 to 38.
Yes, counsel for the appellant
In one, I'm appellant.
in item number 32.
32.
What about the other paper books?
Single paper book for all.
Yes, and other connected matters. Submit that due to unavoidable circumstances, the paper book could not be made ready. Could not be made ready. Stop. He prays funds allowed further 4 weeks' time to prepare the same. Expected that no further time will be taken.
Lordship. I'll leave, Lordship.
May please, Lordship. I beg to mention item number 28 and 39, Lordship.
28 and 39.
Lordship.
What for?
Because this is not urgent matter, Your Lordship.
Non urgent matters. He won't do it.
No, only after 2 weeks, Lordship.
Who's looking for other side?
28, I'm for the state, my lords.
Why? Still holiday mood till now, 2029 after 2 weeks
39.
and 39 after 2 weeks on the parade also.
Next.
Most blessed, Lordship.
Your Lordship, this item 31, we have a joint prayer to take it up on Monday, is next Monday, Your Lordship.
Yes,
My lord.
after 1 week, yes. On the parade party, yes.
My lord, I am filing this there, my lord.
You were not there last. It's
My
the
lord,
same
I-
no, Mr. Jha.
My
You
lord,
should
I-
have made a prayer. Someone should have sent someone else.
My lord,
you
I-
file a miscase for urgency to stay a transfer order. You don't bother to appear.
My lord, I
without
thought-
even anybody appearing. I should have dismissed it.
It's my apology, my lord. I thought I will make it out to appear, my lord, but I could not, my lord.
Okay, but really, the conduct is not good. You file it and nobody comes to appear also.
Sorry.
My Lord, I also wanted to mention one pending matter, my Lord, to be listed Wednesday. This is that school teacher matter where he has deserted the school since 2015. And the other day I have met a prayer, my Lord, that we should be allowed to recruit a new teacher because
You file this application?
misapplication, my Lord, in the order itself, we have written to approval, as
Thursday,
DSDO is
Thursday.
saying. My Lord. Oh.
Yes, on Thursday.
Oh, Friday? Oh, so Wednesday, my Lord.
Thursday.
Obliged.
Please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 40, Your Lordship. Your Lordship, I pray this matter may come up to 2 weeks, Your Lordship.
Why? What's the matter about?
This is with regard to the settlement of fishery, Your Lordship.
The time must be over now only.
No, not yet.
no,
Not yet. Let it be after 3 weeks, madam.
2 weeks, okay.
2 weeks.
40.
Obliged.
Please, Your Lordship, I beg to mention item 29. The conducting counsel is having some personal difficulties. So I pray for 2 weeks, Your Lordship.
No objection.
2 weeks on the screen. Yes.
Highly obliged.
Item number 1.
What grievance here basically is about non-registration of an FIR
May I please, Your Lordship?
against the Prime Minister 5 and 6, my lord. FIR, my lord.
What's the problem? What is
Why
the
don't-
case about?
Your Lordship, the conducting counsel, Mr. N.D. Shulai, is currently on his legs, Your Lordship. I pray if this matter can come at the end of the port, Your Lordship.
Let's hear him. What's the matter about? You're there. Yes.
My,
Non-registration. What FIR?
my lord, there is an FIR, my lord, filed at phase 19,
Page?
19, Annex 5. But alleging that my uses of land has been disturbed and I had a respondent number 5 and 6. Though the police made a ZD entry, my lord, I made a complaint to the SP also, but then still no FIR case has been registered and no action has been taken, my lord. That is the
notice for all respondents, or
No, Your
for
Lordship.
respondents number
1, 2, and 3, Your Lordship.
for 2 and 3 step to be issued, or notice to be issued to other respondents. MS Island got to obtain instructions within 1 week as to the instructions within 1 week from the concerned police station. Yes, after 1 week, yes.
Item number 2.
Wait, please, Your Lordship. My Lord, this is with regards to a ST certificate issued. My Lord, the mother is before this honourable court. My Lord, challenging the ST certificate issued in favour of her son.
On what ground?
My Lord, what has happened here is, my Lord, I got married to a German national. My Lord, I settled in Germany, and thereafter, my Lord, I had 3 children over there. Now, sometimes in the year 2016, I came back over here. Subsequently, my son also came here. Now, during the COVID pandemic, my Lord, I was made to believe that, my Lord, I would not survive the pandemic, and for some reason or the other, my Lord, I was forced to, my Lord, issue a gift deed, my Lord, execute a gift deed in favour of my son. My Lord, that was a kacha gift deed which was done before the wrong Bashano. My Lord, subsequent to that, my Lord, my son took me to the district council and somehow, my Lord, manipulated me in helping him get a Khasi schedule type certificate, my Lord. Thereafter, my Lord, what happened, my Lord, once the property was given to him, my Lord, he made a very different claim. He said that I don't want to share the property with anybody else. Now, I have 2 daughters in Germany. I have a husband who is also over here, my Lord. And subsequent to that, my Lord, he fraudulently has obtained a ST certificate. Now, my Lord, ordinarily, I should have gone before the scrutiny committee if I had any complaint against issuance of a fake ST certificate. But in the state of Meghalaya, there is no such scrutiny committee. My Lord, if Lordship will see, there is a...
How is he using his ST certificate? To what purpose?
My Lord, he has filed a suit before the district council now. He has obtained some status quo order claiming the property, my Lord. So, my Lord, my only prayer before this court is, my Lord, I made file a representation before the concerned authorities. The authorities have not done anything at all. So, my only prayer is...
Mr. Gautam, see, now they have here that Khasi Lineage Act also.
My Lord,
right?
yeah.
Yes, and then under that act, I mean, he's entitled to it. He's the daughter of a...
But, my Lord, he's not an Indian citizen as of now, my Lord. He's still a German national. Now, while applying for a ST certificate...
the proper forum to...
Otherwise, my Lord, if he is a foreign national and he has obtained scheduled caste tribe status in the state of Meghalaya, my Lord, he will get privileges which he is not entitled to.
So the foreign objection means what? Objection has already been granted. If it's in the process, objection
So, my Lord,
will
if you'll see my representation, my Lord,
if objection is there, you'll be heard. What's the objection if it's already been granted?
Well, Lord, thereafter, my Lord, in my letter, I have asked for cancellation of this one. I am saying that he's fraudulently obtained this. Well, at least what is this? If Lordship issues notice, just for the authorities to show what actions they have taken, my Lord, then thereafter, my Lord, if this is a genuine certificate, then my Lord, I have nothing more to say.
How do you say it's not genuine?
Well, because
It's issued by competent authority.
But my Lord, he has not even submitted any supporting documents to show that he is an Indian national, which is the most important prerequisite to get a ST certificate, my Lord.
Yes.
Lordship, first and foremost, this is not the proper forum, Lordship, because if I'm not mistaken, there is a district and a state level scrutiny committee, Lordship.
I could not find any such scrutiny committee. I would have gone there otherwise.
No, it's already been granted, you see, so now it's only for cancellation.
Well, even if it's granted, that can go before the scrutiny committee, my Lord, if there is any complaint.
They can apply to the appropriate forum, Lordship, not to come before this honourable court, because it's fallen from this honourable court's mouth. It's just to frustrate the suit that's pending in the
Well, that is not
trial
correct,
court.
my Lord. If Lordship will see my prayer, I have not asked for cancellation. I have not. Well, I am saying that my Lord, if he has fraudulently obtained a ST certificate, my Lord, if he is not an ST, he cannot even file a suit in the district council, my Lord.
How is it fraudulent? He's a son of a...
Well, that is absolutely correct.
Lady.
That is absolutely correct, my Lord. But then he is still a German national.
Is it a question of someone usurping the title,
no,
land name of someone else?
No, it's a little different from the other cases, my Lord. It's very unfortunate that the mother and son are fighting. But
okay, take down. I heard Mr. KCH Gautam, counsel for the petitioner. MS NG Shilla is present on behalf of the state respondent. What about this is counsel? No one's here.
We've already served notice.
Yes. You're not aware of the case?
We haven't received any instructions
okay,
based on this case.
So on behalf of respondent 1, 2, 3 stuff. Next paragraph. The grievance of the petitioner. or a prepare petitioner by way of the present writ application is for issuance of appropriate directions for conduct of inquiry on the basis of representation made by the writ petitioner for cancellation of the scheduled tribe certificate granted to the private respondent. Stop. It is on perusal of the materials and record is seen that the writ petitioner had approached the office of the District Deputy Commissioner with an objection to the issuance of scheduled tribe certificate. Stop. Of the certificate, and that the grievance is that no, as such, it is prayed that appropriate directions be issued. Next para MS NG Shila Senior Advocate appearing for the respondents 1, 2, and 3 has raised strong objections to the maintainability writ petition and submitted that it's not a matter to be entertained under Article 2 to 6 of the Constitution at this stage. Further submits that remedy for the writ petitioner lies before other forums, not before the High Court at this stage. Having heard the counsel with the petitioner has also perused the materials on record. Stop. It is seen that the matter is at a very premature stage and no mandamus is called for at this stage. Stop. Next, according to the petition disposed of with direction that the petitioner is free to pursue other remedies before appropriate authorities for the prayers made on writ petition.
Much obliged, Lordship.
Item number 3.
Obliged.
Please, Your Lordship, this is a transfer-related matter. I'm aggrieved with the transfer. Before I come to that, Your Lordship, I'd just like to explain you. I am a Havaldar clerk in the law department in the Assam Rifle since 2007. After 10 years in after 12 years in 2019, I was transferred to Shillong of the Assam Rifle.
2013?
2019.
Okay, 19, sorry.
2019. When I was in the law department in 2019, I was allowed to work as a law clerk in the law department. Now, the respondent number 6 and 7 found my service to be very beneficial to the law department and has also certified. I have here a cadet report which they have found me an exceptional employee, and being very keen in the law department, in the legal field.
So what's your grievance now that you're being transferred?
I'm coming to that, Your Lordship.
Yes.
I just want to set what is. I seek permission. Yes.
For consideration of
somewhat related to that, Your Lordship. I was very keen in improving my skills in the legal field. I had seek admission from the Shillong Law College, and that also prior to the seeking no objection from the respondent, which they have happily given the no objection. I have applied, I've got admission in the LLB course. Along with my service, I have also continued my studies in the LLB. And as on today, Your Lordship, I am due to complete my final semester in the month of July 2024, this year. Now, what had happened, Your Lordship, in the year 2021, my parents were having some medical issue, and also because of their old age, I have taken them for medical treatment in the Assam Rifle Multi-Speciality Hospital and also in Nigrims. And because of the ill health, I have to they are constantly required to be monitored by the consultants and the medical expert of Nigrims and also of the Assam Rifle Medical Hospital.
Okay, Mr. Mapa. Now, what is the normal tenure of
3 years. 3 years.
3 years, now 2019. Now you're in the 5th year.
Yes, in 2021, what had happened, I have completed 4 years. Now, what had happened, Lordship? The 4-year extension was not on my request, it was on the organizational interest. Passed an order for for transfer, I have given one application on a compassionate ground. That is in line of the ROI, which is the record of instruction, that as per the guidelines, where there are two criteria. The first criteria is I'm allowed to apply once in my entire service, and the other criteria, it should be before the posting order is issued. So I have complied to the two criteria, which is as per the ROI, the records of instruction. Now, what had happened? The application was rejected on the ground that my tenure was extended for 1 year in 2 spells. Now, that extension was not on my request. It was done in the interest of the organization, which is in the interest of the Assam Rifle. It was not done in my interest. So now the certification with regard to my parents' ill health, the continuous medical checkup is required. So the rejection of my my application under the compassionate ground is uncalled for, Your Lordship. Because why? The approving authority, also as per the ROI, says that it has to be recommended by the medical expert. It's very much, can we come to page 28, the approving authority, page 28 of my writ petition. This is paragraph 14.9. See the approving authority, which is 49G.
No, but Mr. Marpan, see, how can you can't interfere and transfer? The thing is that you already, is a question of untimely transfer.
NOC, they have given me
or malified or, punitive. It's routine transfer.
Because why? The other authorities, 6, 7, and 8, respondent number 6, 7, and 8, they have highly recommended.
From diabetes only.
No, but the remarks, kindly see the remarks. This is at page. The Lordship, this writ petition, my only prayer.
Life checking you need.
My prayer of 2 types, either one of it, may be allowed to remain here till for medical treatment of my parents, or
remain here
till July.
Finish your law, that means.
Sorry.
Basically.
Yes. In Shillong. Until I complete my course.
But I'll have instruction, my lord, but the impugned order is of 23rd August, my lord.
23rd August?
My lord.
23rd
No
August.
one order has been issued.
Yes, my lord.
Then?
No, but I'll tell you, 23rd August, this was modified later. This was modified, and also there was subsequent correspondence.
23rd August is? Yes.
Yes, but there was subsequent.
So. You already been transferred.
I have not moved because of my studies and also because of my parents. And the other authorities, 6, 7, and 8, respondent have highly recommended my being in Setu, which is in Shillong. And can you see the certificate also? The certificate which was given to me in 2021 regarding the commemoration letter that I got.
The letter is dated which? Page 48, 30th October. What is this letter?
October. This is a subsequent letter which was given by respondent. This has acted, the respondent number 5 acted alone. 6, 7, 8 had highly recommended. This was subsequent letter after the first order was in January 2023, and this was later modified on 23rd August 2023. And this is again, it's transferred to the legal department.
See, people are just keeping you here, and other authorities, your company authorities wants you out.
Also considering the fact, Your Lordship, no objection was given to me at the time of taking admission. They know really well that it takes 3 years to complete the course, and also considering the fact that my parents.
No objection will not mean that he will not be transferred, my lord.
So just a couple of months, July 2024, it's coming out.
A couple of months, yes.
Well, I'll file an affidavit, my lord. A short date, but in my humble submission, is not a case of stay, my lord.
I have filed a miscase reason because why there's a threat by the.
There are no compelling circumstances.
There's a threat by respondent number 5 which doesn't have an authority. No, for stoppage of pay.
Naturally,
which the respondent number 5 doesn't have the authority.
23rd of August 23, and you never join, and then he has to make repeated communications with regard to your non-movement of the concerned person.
Correct, Your Lordship, the correct authority for stoppage of pay is the other authority, which is above.
Then he has no authority to do that.
Respondent number 4.
That is other remedy.
Yes.
Sir, Mr. S. Marpan, Learned Counsel for the petitioner issue notice. Dr. N. Mozika, DGSI is present. accept notice
All
on
the
behalf of all the respondents. No further notices called for. Stop. A prayer has been made. A prayer has been made in the interim that the which movement order once stayed. Where's that?
The last order, Lordship, 23rd August 2023.
Yes, has been.
Annexure.
An attempt has been made for staying the operation of letters to posting order dated 23/8/2023, whereby the petitioner has been transferred from Shillong to
Aizawl.
To Aizawl. Stop. Notice on the interim, expired notice on interim stay. Respondent to seek instructions or file affidavit within 10 days. List that after also.
Item number 4.
Those matters.
Lordship, in this matter, out of 193 petitioners, 143 have already received the compensation. 50 have not received it because they say it's inadequate. As per the last order of the 6th of December, we were required to put this on an affidavit, but we've received it only on the 2nd of February, the instructions, my lord. The entire list of all the...
Why not accepting? Why the other 50 people not accepting? No, forget being supposed to file. Why not accepting the other 50?
No, we are accepting. Only thing is that they are, what I got the instruction is they are paying not a sufficient amount. Actually, they are taking into the consideration the notice issued by the district council.
You can always take any payment or protest. Don't need money. Okay, Doctor. Mr. S. and another senior government advocate.
1 to 4.
Appearing for respondents 1 to 4 submits that instructions with regard to the receipt. Instruction with regard to the purchase of received compensation has just been received the 2nd of February. The praise funds allowed 2 weeks' time to put the same affidavit and file for the next date. Yes.
I'll oblige.
Much pleasure.
Item number 5.
Meet His Lordship.
Yes.
Lordship, in this case, the lease has been signed. We have been given the allotment order. We will vacate the premises and hand over vacant possession. Only some time will be required, Lordship.
To whom vacant possession?
To defense.
To the defense.
What about the DPR regarding that flyover?
My lord, the state can communicate.
Whatever the state does, state takes over. We walk out.
Yes.
Lordship.
What instructions?
Lordship, as of the Lordship, as per the last order,
Can
they
we
were
see the
supposed to get some instructions of the certificate, Lordship, that we have produced before this honourable court, Lordship.
Yeah, that's what I said.
handing over, taking over?
Lordship.
Yes, Mr. Khan, last time you supposed to take instructions. So the lease been signed?
Lease been signed.
Yes, the council, MS M. Hazireka, London Senior Council, with so appearing for the respondents today submits that the formalities such as the lease has since been executed. Yes. Only what remains is for?
Lordship, we have to shift.
To hand over the vacant
hand over
and the portion
hand over the vacant
possession. Physical possession, handing over physical possession
by vacating
of the premises in question by vacating the same. Stop. For this, how much time do you require?
9 months.
9 months.
Oh, no. 3 months, my lord.
No, let it be 6, Lordship.
Yes.
3 months, Lordship.
6 months.
3 months be difficult because it's.
I think the tanks and other things have already been removed.
They've been removed.
No, it has not been removed. 6 months we'll need. Tanks will be removed.
Okay, we'll put it at 4 months then. Stop as reported by the parties that extensive what have we done? Extensive work has to be completed in the site before handing over. A period of 4 months is granted to the petitioners to hand over vacant possession.
To the defense authorities.
To the defense authorities. So we'll close the petition then?
Yes.
With above your direction, petition stands closed. Yes, and this goes down.
Item number 6.
4 months from date of order.
Please, Lordship. This matter is fixed for hearing, Lordship.
Why is fixed for hearing today? What's the matter about?
It's about reconstitutions of the managing committee, Lordship.
Why is fixed for hearing today?
Is it
in the order column or in the hearing column? This one?
Order column.
It's in the order column, Lordship.
Yes, start.
No, Your Lordship, I'm praying for some accommodation, Your Lordship. Mr. Paul is out of station.
On whose instance was this matter fixed for hearing today? Hearing?
No, it cannot be. Cannot be.
And 8, 9 and 14, who's appearing?
Cannot be.
You have not filed a vakalat till now?
File it today, Lordship.
When you file it today?
Fixed for hearing?
Mr. Aring. Jishilla 5, 7, 10 to 13. Who's 5 to 7, 10 to 13?
Yes, I am appearing on behalf of Jeshila.
State Lafayette.
When's the managing committee expiring term?
Expired for...
Ad hoc, yes.
No period has been given.
Yes, all right, yes.
Yes.
So this is Naitang, ne? Yes, Naitang behalf of the petitioner prays that some accommodation be given due to the absence of the senior arguing counsel. Stop. Though this matter was fixed, was listed as a fixed matter for hearing today, in view of the prayer of the petitioner, this is same for 2 weeks. Mr. L. Aring to file the vakalat on behalf of respondent 8, 9 and 14 in the course of the day. Yes.
Apply,
this 2 weeks. Yes.
Item number 7.
Yes.
My lord, this matter is still pending before the apex court, and the appeal before our court is also coming up tomorrow, my lord, Hemberley.
But then tomorrow also nothing happened. Yeah. This is matter after 6 weeks. As the matter is pending consideration of the Honorable Supreme Court.
Item number 8.
Parties at liberty to mention if there is any outcome before the next date is. What under it?
We are filing the replication to the show cause reply filed to the Order 7 Rule 11 application.
I can't hear you. Yes?
Your Lordships, 7-11.
Yes?
Your Lordships, am I audible?
Yes, yes.
Your Lordships, we are filing replication to the show cause reply filed to the Order 7 Rule 11 application, Your Lordships.
When?
Today, Your Lordships, we are filing it today.
It will file today?
Yes, Your Lordship.
Yes,
Yes, Your
application to the show cause to 711 application has been filed today by the respondent. Stop. Let's list the matter for hearing on the next date. So yes.
Obliged, Your Lordships. Obliged, Your Lordships.
Item number 9.
Your Lordship, I'm filing my affidavit during the course of the day, Your Lordship. I've served a copy to the petitioner, Your Lordship. Just this morning.
Yes, Mr. Abraham suggests that he has to be filed in the course of the day. But this is matter for 2 weeks.
10 also connected, Your Lordship.
Same order, 10.
11.
My Lord, in this case, the pleadings are already complete, my Lord. This is regarding the election of Doloy in the Gente Hills, my Lord. My Lord, pleadings are already completed. My Lord will take up the matter because if the other side is ready, we can take.
What urgency is there?
My Lord, there are some rituals to be performed.
Who will stop the rituals being performed?
But Dolo is required, my Lord. He is the person who will conduct the rituals and also.
Who's the unofficial Daloi now?
Now, no Dolo, my Lord.
There's no acting Daloi?
No, my Lord.
There's no acting Daloi?
But an acting Daloi that he was removed because he was participating.
Even the acting Daloi has been removed, my lord. There's no.
Why removed? Or because he was the candidate only.
The administrator is taking care, my lord.
Administrator has been removed also.
No, he's there, my lord. But administrator, I think you cannot.
After 1 week, my Lord, I have no issue, my Lord.
And that by some complete, as some urgency has been expressed, as a matter of the 1 week is.
Obliged.
Item number 12.
Lordship, I was required to file my rejoinder, Lordship, which I have done this morning, Lordship.
We received the copy of the rejoinder affidavit.
I'll submit, please complete this matter for hearing.
Obliged, Lordship.
Also.
13.
Lordship, here I have filed my counter, Lordship.
You paid 1,000 rupees?
Yes, Lordship.
You received the affidavit?
Yes, Lordship, this morning.
Mr. S.A. Sheikh submits that after it's since been filed and also the cost of 1,000 has also been deposited with the registry. Then you want to file the rejoinder? What do you want?
For rejoinder, Lordship.
This matter for hearing. After 3 weeks, petitioner may file the rejoinder in the meanwhile. Yeah.
All right, Lordship.
14.
Please, Your Lordship, in item number 14 and 15, these are connected matters. We have received instructions, but these are inadequate, my lords. We'll require these instructions we've received, but these are not proper instructions, they're inadequate. We'll require further clarification. May I just pray for another 3 weeks' time, my lords?
Private respondents are also there, my lord. They are also yet to file there.
You're not filing affidavit?
3 weeks will be too long. 2 weeks will suffice, my lord. Since they have already received
That's obtaining instructions in several
days. You're for number 5. You're appearing for 124. Mr. S. Sender on behalf of number 124. It's also for 5 3 for a lot further 2 weeks time to file the affidavits thereafter and so on.
Obliged.
Obliged.
16.
Also the petitioner here. They've collected the amount.
No, Your Honor. No, Your Lordship. We went twice or thrice, Your Honor, Your Lordship, but the authorities are delayed in releasing the compensation, Your Lordship.
I had in fact communicated to the council that the amount is ready, lying ready for payment. This was not known to me, my lords. I'll speak to the department, but they're ready for disbursement of the amount.
Mr. B. Motor, Your Lordship.
They went to collect the amount?
Yes, Your Lordship. We went twice or thrice, Your Lordship.
How is it possible then?
I'm not aware of it. They could have told me about it, in fact. So I'm in touch with the officer.
Mr. Motho, Legal Counsel submits that the amount as indicated in the communication dated 13/11/2023 is yet to be received in spite of the petitioners approaching the concerned authorities. Mr. SN submits that this is not to the knowledge of the respondents. Accordingly, he is directed to obtain instructions and intimate the petitioners to collect said amount. You do that also? Just after 2 weeks.
17.
Yes.
Your Lordship, we have filed a rejoinder affidavit, Your Lordship.
Today?
No, Your Lordship. We filed on the 29th.
What's the matter about?
Administration fee by the petitioner, Your Lordship.
You ready for hearing today?
Lordship, this matter could be fixed in another date.
Okay. Party submit the pleas are complete. This is a matter for hearing after 2 weeks. Yes.
Much of that, Your Lordship.
18.
May I please, Your Lordship? Your Lordship, I have already filed my counter affidavit, Your Lordship.
I'll file a short rejoinder, just 2 weeks' time.
Yes, Mr. SN prays for allowed 2 weeks' time to file the joint. The affidavit filed by the respondents. This is thereafter and so on.
Obliged.
19.
This matters that said what?
My lord, this in this case, state is yet to file the affidavit, my lord.
No, it's connected to some other matter that.
Yes,
Item number 20.
It's item number 20.
Item number
I believe it will have some bearing on our case as well.
My lord, I have been taking of this case along with the 20.
Why?
It has got a separate cause of action, my lord. And the one 20 has got different subject matter. It's required to be taken separately, my lord.
Item 20. Have you filed objection to the misapplication?
No. In item number 20,
20.
20 state is not a party.
No, the Mr. Who is this?
We are supposed to file the short my lord, I need 1 week time, my lord, because I was not here in Shillong for a long time, my lord. And only
Where were you? You were in?
I was in Calcutta, my lord.
Oh.
I came only today morning. Only 1 week time, my lord.
Why you don't have a bearing?
Your Lordship, may I draw your Lordship attention?
Yes.
In item number 19, your Lordship, I have prayed for that the matter be connected because they have made allegation against me. I am a necessary party as respondent number 3, and I have made a mention as a headman. During my tenure as a headman, Lordship, there was some matter related to the receipt of the compensation. So by virtue of when I received the compensation, allegation was made that I have received on my own account. But that, your Lordship, I have filed a reply. I have filed an affidavit which was on board, your Lordship, with respect to item number 19. The money has already been 4.5, your Lordship, acknowledge of the payment that I've made, your Lordship.
You're not party in this item number 19.
I am, your Lordship. I'm respondent number 13.
Oh, you're there then.
Yes.
Oh, you Kambarlong or Kadiang what?
Kamborlang, Khashandi.
And petitioner here is through?
Is
in number 20?
In number 20, petitioner is one is Kishin.
Oh, number 2, petitioner number 2 is Kambarlong.
Number 2 is
Hasandi.
Yes.
Okay. Mr. Nanda, you file your objection then. We'll hear it together.
Yes, Your Lordship.
May I just pray, just to understand what the subject matter of the item number 20 is, we may be supplied with a copy of the writ petition.
Yes.
Yes, Your Lord.
Yes, Mr. H.R. Nath, these matters have been listed together today, or this matter, item 20 first. This matter was listed along with WPC 296 today as the party in 6 are common with the instant petition stuff. And H.R. Nath submits that due to personal difficulty, this application number MC WPC number 231 of 223 cannot be filed. He prays funds allowed 1 week's time to complete the same. These matters, this together with 296 after 1 week.
296, my lord, state
no,
is...
That day you will say?
The state is yet to file the affidavit.
So we've received instructions, my lord. I just wanted to compare with item number 20.
No, we are more concerned with that 20, but then if there's a bearing, we'll refer to it as well. Cause of action is different, but parties are the same. Matter ready for hearing.
No, Your Lordship. I humbly pray 2 weeks' time, Your Lordship, to file affidavit.
What's the matter about?
This is a Gambura matters, Your Lordship.
Nokma matter?
Gambura. Appointment of headman.
It's only an apprehension that have you been removed? He's still in office.
He is suspended.
Suspended?
Yes.
Where's the suspension order? Where is it?
It's not enclosed, Your Lordship. Lordship, it's not there with me right now.
He's still in office, that means. And how is his reputation entertained?
Post of a governor.
He's still serving now. You have not cancelled the appointment.
I have to update instruction, Your Lordship, for that matters only.
We're an expert in Gawbara matters. Correct? No. Writ petition appears has been filed in apprehension of a proposed removal office of the writ petitioner. The MS and Raji to obtain instruction within 1 week. List the matter for 1 week. Then this matter will be closed. In apprehension you file.
22.
Oblige, Your Lordship.
Okay.
Affidavit, my lord.
Yes?
To file an affidavit, my lord.
You haven't filed affidavit, Dr. Mozika?
My lord, the instruction is, my lord. My lord, the instruction is the matter has been resolved, my lord. I'll give him a copy, my lord, if the matter can come up tomorrow morning.
And Mozika, DGCI submits that he has been informed the matter has been resolved. Instructed to place the instructions of the CM tomorrow. Yes.
23.
May it please Your Lordship, I'm yet to receive instructions, Lordship. I pray for some further time.
Yes, Messenger, please follow up for the 3 weeks' time to obtain the file affidavit.
Much obliged, Lordship.
Yes.
May it please the court, my lords. Plus, the respondents have filed an affidavit challenging the maintainability of this writ petition. Now, my lords, if I may, my lords, the respondents have, in fact, made a valiant effort to impress upon this honourable court that the petitioners are aggrieved with the order passed by the recovery officer. When in fact that is not the case, my lord. Nowhere in the writ petition have we assailed the order of the recovery officer. Now, if your lordship may kindly come to the affidavit that has been filed by the respondents. Now, they have raised the issue of maintainability on one account and one account alone. They say that a person aggrieved with the order passed by a recovery officer has to invoke section 30. Is that the recovery certificate has to be assailed, my lord? In the instant writ petition, that is not the case. We are not at all aggrieved. In fact,
what are you assailing in writ petition?
my lord, for that I'll have to take your lordship through the writ petition. Come to the writ petition at hand. Your lordship, the order that was passed by the DRT will have to be perused. Now, an application, something in excess of 8 crores, and that was decreed in their favor. I'll take your lordship through the relevant portion. In the counter affidavit also it is mentioned, but internal page 12 of the order. The directions, a slew of directions were issued by the DRT. The same is available at page number 23. At serial number 12, your lordship has it. Serial number 12. The operative direction. If I may read it. Issue recovery certificate accordingly for a sum of rupees 8 crores 39 lakhs so-and-so in favor of the applicant bank against the defendant numbers 1, 2 and 3. So it is amply clear that the DRT had ordered for recovery of an amount of 8 crores. That being the position. Now, Your Lordship, the amount that they have in fact recovered from us. The very next page, page number 24. Intimation of sale of so-and-so, serial numbers 1, 2 and 3. Serial number 1, Your Lordship, sold at a price of rupees 4.4 crores. Okay. Serial number 2, sold at price of rupees 1.43 crores. And serial number 3, sold at price of rupees 2.83 crores. Yes. Which comes to somewhere around 8.69 crores, my lord. The DRT order was for a recovery of 8.3 crores and they've recovered in excess of 8.6 crores. Now, even after fulfillment of the mandate of the DRT, now they want to sell off another property of mine.
Where is the property?
Well, that property is here itself. Now, they have approached the DRT at page number 25, Your Lordship will see. So, CHB has filed 2 valuation reports of mortgage property mentioned in Schedule B. As per valuation report given by so-and-so, realizable sale value of the mortgage Schedule B property is rupees 3 crores 42 lakhs so-and-so, and valuation report given by so-and-so. Now, we have only 8 crores.
Mr. Sahu, pre-response allowed 1 week's time to file the rejoinder to the affidavit filed by the respondent list after 1 week.
But one would be a little short. I would like.
2 weeks. No, Lordship,
they have already
got let them file the joinder, we'll dispose it off. He knows. Yes.
Deeply obliged.
Hearing, item 25.
This is the tender matter, my lord.
Where's your...
My lord, he will be appearing through VC.
Okay, after some time, let's take up these other matters first. Tell him to be ready.
Oh, he's there.
26.
Oh, you've come. Yes. Like a genie out of the bottle.
No, I was there in court number 3, so just finished one there. Beloved, if your lordship will see my additional affidavit, where I have put every content, my lord, in short form. Your lordship, kindly see paragraph 4 first of page 2.
Yes.
Miscellaneous application is not maintainable, so and so, my lord. Second line, it is submitted that relief sought in the miscellaneous cannot be beyond the prayers made in the writ petition. In present case, petitioner in writ petition has sought the following prayer, my lord. B. Declare that MEPDCL to reject the petitioner bid is illegal and arbitrary, being contrary to provisions of NIT dated 25 other bidding documents, and restrain MEPDCL from proceeding with the bid proceeding inviting NIT for appointment of advanced appointment of advanced metering infrastructure service provider for smart prepaid meter in Meghalaya on DBF foot basis in view of illegal so-and-so, and declare utility consent, declare the term utility contained in the bidding document including RFP only confines to MEPDCL and subsidiary and holding companies. So this was the prayer, my lord. And then next, a bare proposal of relief would show that same pertains to rejection of petitioner's bid in respect of notice inviting tender dated 25/11/22. However, by way of present miscellaneous application, petitioner has sought relief seeking honorable court to restrain the respondent from proceeding with fresh tender via the NIT dated 15/1/2024 floated by respondent for smart metering on design, build, finance, own, operate and transfer basis. A miscellaneous application is, my lord. Now, this next paragraph 5, my lord. Honorable action cannot be agitated by way of miscellaneous application in respect of subsequent event. It is humbly submitted that this honorable court has no jurisdiction to decide an issue outside the scope of original litigation by way of miscellaneous application. Reference may also be made to the judgment of the Honorable Supreme Court. No miscellaneous application can be filed in the writ petition to revive proceeding in respect of subsequent event after 2 years. Even respondents was aggrieved by the notice dated, he could the validity of notice, etc. My lord. Now, kindly see why we have made the amendment, paragraph 7, my lord. It is submitted that respondent as an employer has right to recall the tender in public interest. It may be noted that NIT dated 25/11/2022 specifically conferred the said right on to annul the tender process, and respondent has no liability towards any of the bidder. Relevant clause is, my lord, 8, last bold line. Utility is not bound to accept any proposal and reserves the right to annul the selection process at any point of time to contract without their incurring liability to the bidder. Then 26, my lord, take such measures as it may deem fit, etc., my lord. Paragraph 9, my lord. It is submitted applicant has incorrectly stated respondent acted in malified manner in ensuing the field. It is submitted firstly such allegations are beyond the pleading repetition and miscellaneous. However, without prejudice to the other content, it is submitted that cancellation of the previous tender process is in public interest. In this regard, the points made subsequent paragraph may kindly be noted, my lord. It is submitted that instant application by petitioner is an abuse of process of extraordinary repetition by Honorable Court. Purvanchal Vidyut Vitran Nigam Limited, while order dated 6/1, debarred the BCITS for a period of 2 years from taking participation in all tender work of PUBNL for a period of 2 years from the date of issue order. The clause 2 of RFP provides that it is the duty of bidder to inform the utility of any such order passed by any other utility. It is relevant to state that order debarring BCITS was passed by PUBNL on 6 January 23. The said information was not disclosed to the employer. Petitioner company has been blacklisted by Uttar Pradesh State Discom for participating in any tender work. However, by way of instant, company seeks for stay of fresh tender process, stay of fresh tender. It is submitted petitioner under the guise of instant has sought to undermine the fresh tender process, jeopardizing public good interest for individual gain. It is submitted that petitioners are part of consortium who entered into bid in on 25th November 2020. It is submitted that petitioners were required to submit an undertaking to the fact that they have not been blacklisted or debarred by any cause. Clause 4 of the bid document of tender dated is quoted below, my lord. The bidder participated in the bid as a sole bidder or the consortium should not be blacklisted by any government organization or regulatory agency or government, and bidder should submit a self-undertaking signed by its authorized utility to modify clause of blacklisting. It is submitted the first tender of 15 January is in furtherance of suggestions of REC. A copy of letter of 26 is annexed here.
Let's see.
Annexure 4, my lord. Annexure 4. Page 86. Page 86, my lord.
Okay.
My lord, there are other so many complications, my lord. And your lordship kindly see the other part of my affidavit.
This is to all discoms.
So all discoms,
the entire modified clause and put in a new tender.
Yes, my lord. And your lordship has seen, because now what my mission, my lord, for your lordship's kind consideration is that so far as Aparva is concerned, my lord, Aparva is basically hardware manufacturer and BCITS is a software. That part I have also did. So Aparva can have the consortium with any other bidder, my lord. Aparva is not blacklisted. That part have also been explained, my lord, in paragraph 22, my lord. We are not against any company, my lord, but we have certain constraint. Lordship will see that part also we have said so. Paragraph 18, my lord. Paragraph 18.
You've seen annexure E4, page 86?
Page 86, my lord.
Yes. It's from the regional...
My lord, this is dated 22nd of June 23, my lord. The
tender was floated when?
In November 22, my lord. The first tender was of November.
That is what amendment balancing the boundary provisions. So this are they bound to comply with these directions?
My lord, once a tender has been issued, in my humble
but what has developed the situation that you are in? That is why, like, do you think it's not within the power to modify? I thought it was a question of modification at their own instance. That this new clause have been put in to just shut you out from the tender process. But if with a modified clause is as per the stipulation of this Rural Electrification Corporation.
One paragraph, my lord. Kindly see paragraph 18. We are not shutting them down. Kindly see paragraph 18, my lord.
No, I mean, as they stand now.
In fact, Aparva, my lord, Aparva is...
Was the impression that the tender was recalled and the clause modified?
We are not shutting down Aparva. Kindly see one paragraph, my lord. 18. Kindly see paragraph 18 of page 11. That as on date of REC had impaneled about 51 vendors who can participate in smart metering work. It is submitted that fresh tender process gives opportunity to eligible vendors in terms of NIT to submit the bid for tender. It may be noted, Mrs. Aparva has chosen to tie up with BCITS, which is a company that has been debarred. It is submitted that conduct of petitioner. So because Aparva can tie up with any other vendor, my lord,
No, that is never come.
DCITS is
No,
the
no,
only.
but the only thing is the premise on which the the recalling the tender and the and the insertion of this clause. This court under impression that it
Because
was a
we are-
unilateral action on the part
no,
of the
that,
MPDCL
no, no,
in
none of the
My
matters.
lord, as I pointed out on the last occasion, my lord, I pointed out 2 orders passed by this honorable court, my lord.
We will never try to overreach, because if I have to do something, then I have to approach your lordship to, if that was the intention or that was we will get thing. But we will not try to overreach the courts of justice, my lord. That lordship rest assured, whenever the matter comes, we will not do
in
that.
this case. This is exactly what they have done, my lord. I pointed out 2 orders of passed by your lordship, my lord. The first is the order of 18th October, my lord.
And we have given the impaneled.
Can I just pause a bit?
Mr. Advocate General, one second, yes.
Your lordship kindly see, so 18 is the list, my lord. 17 is the list.
Let them say. You made your point, yes.
My lord, I pointed out 2 orders passed by your lordship, my lord. 18th October, your lordship has said that the process of tender will be subject to outcome of the writ petition, my lord.
Right.
Matter, the final hearing commenced on the 19th of December, my lord, and for some reason hearing could not be concluded on that day. Matter is kept part-heard, my lord. On the face of these 2 orders, my lord, without any leave or without any permission from this honorable court, my lord, and that also the sequence of events will indicate, my lord, that initially they have technically qualified us, my lord. Our financial bids are opened, and what we understand, my lord, that we are the successful bidder financially also, which has not been denied by the learned advocate general, my lord. So, my lord, in my humble submission, certain rights vest in us, my lord. And in such situation, what they do, my lord, they ask us to extend our bank guarantee. Not only once, my lord, twice. And then one fine morning, they send us a letter of termination, my lord, saying that because you have been debarred by Uttar Pradesh, Uttaranchal utility, my lord, so you are disqualified in terms of the tender conditions, my lord. Now we come back to the tender conditions, my lord. Now tender conditions, if I may point out, my lord, tender conditions clearly envisage 2 different situations, my lord. One is blacklisting and one is debarment.
Yes.
Now may I point out those clauses, my lord, for a moment, my lord.
But only one thing, Dr. Mosika, is that this other aspect of which this case rests on is that this subsequent event, now whether it will warrant a filing is a fresh cause of action or not, that's the only thing. You're saying continuing cause of action, correct? Now, whether it's a fresh cause of action, whether it can be sustained by the minister's application.
My lord, what I would pray in that situation, my lord, that is under my consideration also, my lord. My lord, because we are short of time, my lord, 7th is the date. If lordship kindly grants us a limited time, my lord, maybe a 5 days time, my lord. Today we are on 5th. Some limited protection, my lord. In the meantime, we'll file a writ petition, my lord. Both the matters can be heard together and disposed of, my lord.
Because you see, coming back again, that with regard to the extent of their, the prerogative by way, like being the owner of the contract, whether, suppose, notwithstanding other circumstances or circumstances that exist as with your case, whether they're well within the powers to recall a tender and issue fresh, if there's some,
my lord,
if there's some considerations which are sustainable.
My lord, to have power is one thing, my lord, but the manner it is exercised, my lord. When we are technically qualified in the financial bid, what we understand, my lord, subject to confirmation with the Learned Advocate General, that we were the L1 bidder, my lord. And on the one of the hearing, my lord, the submission was made by Learned Advocate General that they'll offer L1 price to L2, my lord. And if they don't accept, then they'll re-tender the matter. This was the submission made before your lordship in one of the hearings, my lord.
So you mean to say that?
So, my lord, before doing that,
scenes, they already offered L1 rate to L2.
L2, and it appears that L2 did not accept the rate, my lord, and that is why that has accentuated the situation that can recall the tender and issue fresh tender, my lord.
But the basis on which they have amended the tender conditions, that is in line with the regional electrical authorities.
My lord, here this is in of the process, my lord.
See, that's the thing. Condition of process, yes. But then that goes against you in the sense that it is not a unilateral action on their part to put in those terms. Correct?
My lord, in my humble submission, once because this notification or this circular cannot have retrospective
if your
effect,
rejection has gone and the whole tender process earlier has gone, everything goes. Correct? Everything goes.
My lord,
It's a clean slate again.
My lord, in my humble submission, they cannot do so, my lord, when the matter is sub judice before your lordship, my lord.
Whatever we can say, generally, that's what I'm saying.
My lord.
Suppose it's a clean slate. There have been
My lord, if you-
other cases also went to frustrate successful bidder, tenders been recalled.
My lord, if you are not before your lordship, if there were no 2 orders passed, my lord, in that case, I admit, my lord.
This other case also, which is argued on the other side, some toll gate case where, they're totally frustrated, everything shifting the...
Of certain any interim orders passed by this honorable court, my lord. My lord, this is a way to circumvent the order passed by this honorable court, my lord, and they don't want to. Then they don't want us to be there, my lord. This is very clear from the conduct,
facts
my
are
lord.
not before this court. What is transpired until we see the records, whether it's recorded, we don't know. See, what are the reasons for which a fresh tender was called? We don't know.
My lord, in my humble submission, the only reason is, my lord, they want to throw us out, my lord. And for that, they looked for some handle here and there, and this is what they found, my lord.
No, but what they've brought by the document REC, that does show that it is.
My lord, this is of June 23, my lord. Once we qualify in terms of the previous tender, my lord, and that was issued in the month of November, my lord.
Now, how will you seek to sustain a previous tender now?
I placed on the last occasion this more or less similar circumstances, my lord. The Supreme Court said no. You go by the first tender, my lord.
But is that on a missed case, on a fresh petition, on a fresh proceeding?
My lord, in a fresh proceedings, of course, my lord.
Then that is what.
So, my lord, what I am praying, my lord, at this stage, my lord. But my lord, you will kindly appreciate that tender process is of November 2022, my lord. 5 days protection to us, my lord. Because if they finalize the tender on 7th, my lord, will be totally non-suited, my lord. Matter will be rendered infructuous, my lord. Of a limited protection till 10th is given, my lord. By 10th, we will file.
Preventing you from
tendering.
What's preventing you from tendering into a new consortium with someone else?
My lord, there are 2 aspects of the matter.
There's nothing against you.
My lord, there are 2 aspects because these 2 companies, my lord, have participated in several other bids, my lord. A blacklisting or debarment by MEPDCL will have a long-term effect on the business reputation of the company.
We have not blacklisted, my lord. We could have blacklisted. We have not blacklisted. That power was with me, my lord, for suppression of the fact.
They cannot blacklist, my lord.
We have blacklisted, my lord. We have come out with a new tender. We could have done it because that's a case.
They don't have power to blacklist, my lord. We have not done anything wrong to them, my lord. How can they blacklist us, my lord?
We have given a wrong declaration, my lord. That I can argue before your lordship. My friend can't give the judgment on my submission.
They have not done any blacklisting, my lord. So we do not need to argue
what my
on
friend
that,
says,
my lord.
department is not blacklisting.
But my lord, what I am praying, my lord, kindly give us 5 days time, my lord.
And your lordship has seen time-bound project, my lord. It is a
my lord, time-bound project till 26. We are in early part of 24, my lord. And the tender was issued in November, my lord, November 22.
They have filed, my lord.
They could not finalize it for 1.5 years, my lord. They can definitely wait for 5 more days, my lord.
Kindly see the page 91 where they have approved the tendering of in the pre-bid meeting, my lord, after fresh tender, my lord. Query is also there. That aspect has also not been disclosed, my lord. Page 91. Additional affidavit which we have filed today, my lord. Kindly see page 91 and
page 91 has no bearing, my lord.
91, that fact should have been disclosed. We have to come with clean hands, my lord.
It is not a material fact which has been suppressed, my lord.
My lord, kindly see. They are all in the process of BCITS is, my lord. Chief Engineer, appointment of advance, find below query in respect of RFP, subject to following terms and conditions. So they are going ahead with the fresh tender, my lord. And similar query is by 94 at page by Aparva, my lord. Page 94, Aparva. So there are 51 vendors enlisted by REC.
One thing, Mr. Dr. Mozika, in this speech 91, you requested for modification of the clause in line with RDSS clause.
They have not replied to this, my lord.
They do not place.
You could file a missed case. Why couldn't you file a petition?
My lord, the court just reopened, my lord, and the client. We can file in the next 5 days' time.
Hangover.
One day overnight we have prepared this and we have filed it, my lord.
No, because see, that whatever it is, there is some. It's not a question that you don't have a case at all, but only the fact we have to knit the facts together to see whether their case is sustainable. That's all. But prima facie, yes, maybe. That's the only thing. That's what worries the court. That whoever comes here should not go back. If they have
Your
a case.
Lordship will definitely weigh. Your Lordship will definitely weigh because
the matter
Aparwa
will be listed on 12th, my lord. Matter is listed on 12th, my lord, next Monday, my lord. We will file our writ petition by then, my lord. But they should not finalize it on 7th, my lord. That's the only concern.
Your Lordship, without writ petition, without making out prima facie case, without making any case, they are saying that we should not go ahead with the public tender which is in public interest, where we have to do it in time-bound manner. The Lordship will weigh public interest and private interest. It is his personal interest which he is trying to.
This is not a public interest. This is a writ petition, my lord.
They are not participating as by way of consortium. Ultimately, we have to do this
kindly see the expediency, my lord. In the previous tender, they waited for almost 15 months.
They have to make out the case, my lord. Balance of convenience, prima facie case, some case to make out a case for interim release, when we know that everything we have acted in bona fide manner, and they are saying, look, I know,
the
lost
main
his power in
fixed hearing, like on reopening, I think. And then the process already on whatever, just on that point, they were and blacklisting. And that leave of the court, that was done. I mean, that's the only thing. That only jars the conscience. Otherwise, other things, you're well within your powers.
Your Lordship has heard this matter in detail when I showed that debarment is blacklisting by the declaration made by Government of India, my lord. Then at the end of short time, my lord, when I was about to establish my case before your Lordship, at that stage the matter was deferred, my lord. Almost argument was concluded, my lord. And here what we have done, have we done anything wrong?
They're supposed to file 5 pages, 100 page affidavit, my lord, and they serve 15 minutes back, my lord.
Has done any, they are blacklisted company or not? I put a question to myself, my lord.
We are not blacklisted company, we are debarred company.
Central government funding is, when central government funding is involved, when central government is breathing on my neck all the time, and we are having difficulties in recovering T&D losses, my lord. All these issues are mixed up in this matter, my lord. If all those issues are there, that's the only submission I have to make.
Yes. We understand. We appreciate that. We appreciate that. Only thing is the manner in which it was done, and that whether they were given. We should give a full opportunity to. We will decide the matter. It's a prerogative to issue fresh tender. It's a prerogative to issue fresh tender, and they also, from the materials, already sort of taken part in the preliminary kind of negotiations by asking for amendments to the query. Only thing is that orders of the court were that is a final hearing, and it would have been, the propriety demands that at least, that should have been brought to the court if any proposed action is supposed to be done.
Your Lordship, my friend has disclosed, my lord, that I made the submission that we will take certain steps. Otherwise, we will go for fresh tender.
With the leave of the court, my lord, they cannot do it unilaterally, my lord.
My friend has conceded, my lord. Had there been any intention of not, we were truthful from very first day, but BCITS was not truthful, my lord. Because we have nothing. This is a exercise which your Lordship is undertaking to see that root by
7th, my lord.
7th.
And I'm asking, and
if they want to challenge, let them challenge, my lord. If they have first, they have to
let them challenge. Don't open it. Don't close the date. Close it on the 13th. Before that, we finish the matter.
My lord.
Your Lordship will not pass the order.
I don't think Dr. Mozika also on the fact that you stand and in view of the RCS, REC stipulation that they have not done something which is extraordinary. Is that?
And public interest, my lord, even in absence of REC, it is in public interest.
We have to get I will file the fresh petition on 12th, my lord.
Yes,
we have to do it in time.
An affidavit in reply in this case number 11 of 2024. And LPC number 337 of 2023. An affidavit as objection stroke affidavit to Miss Case number 1124 has been filed by the writ petitioner. Reasons have been set out with regard to the recall of the fresh tender and the stipulations of the RAC which had occasioned the change in the tender conditions, which the writ petitioner has alleged to be arbitrary and made with a view to oust them from the tender process. It is further noted that it is not exhaustive in its pleadings, as as compared to arguments made before this court today. Stop. Next paragraph. It is true that a witness's application will not ordinarily not be maintainable when a fresh cause of action arises. But however, in the present case, in view of the existence of earlier orders of this court dated 1810-23 and 1910-23, where the matter was in the final stage of hearing, the matter deserves to be heard at length. Stop. In this view of the matter, taking the further fact that the fresh tender, the date of final submission of bids of the fresh tender dated when it was voted on.
My Lord, one submission I have just received one instruction, my Lord.
1 second. Fresh tenders voted on. The closing date for the submissions of tender bids to tender floated on so and so is on 7th. On 7th.
7th February is opening date.
No, when's the tenders floated when?
15th January 24.
Taking consideration. Puli and Dari. Stop.
The other fact that the closing date for submission of tender bids is on 7th.
Yeah, on the tender floated on 15/1/2022, it is directed that the last date submission tender shall. It is directed that the respondent corporation shall extend the date of acceptance of tender till the 12th, till the 30th of February 2024. Stop. Matter is will be taken up and heard before the said date. Yes. We listed on.
One submission.
We listed on today is 5th.
Today is 5th, my Lord. On 12th.
We listed on 8th. List on 8 too.
Your Lordship may have it in. Your Lordship may have it in 12th because writ will be filed and then 12th.
No,
Your Lordship may have it on 12th.
A writ petition. If they can't file it, it's too bad. That's all. On 8th, I'll go
so
to the matter.
Your Lordship may have it on 12th. Okay, Your Lordship. Only thing is, my Lord, that 7th is the bid date. The bids are expiring, my Lord. So the corporation will have to extend the bid validity also. Validity also, my Lord. We'll have to extend that. We have by corrigendum. We will extend the bid validity till Your Lordship has said till 13th.
You can sell the 13th or you can sell the 15th. If you want the matter to be heard on 12th, then we extend it till 15th.
We'll do that.
Yes, till 15th. Yes. Matter to appear on 12th for final hearing. We'll finish it off because even Mr. Ramisa, the court not really convinced with the cause of action. I mean the course they've taken. Only the proceedings were at culminating at the final stage last time. That's the only thing we'll see. But regarding the modification, I don't know what. So, by this order, don't expect that that the battle is won. No.
26.
Court still very. Yes. Yes.
Online. Yes, madam. Item 25 and 26 are connected matters, my lord.
26 and 27.
26 and 20. 26 and 27.
Yes.
These are connected matters, my lord.
Yes.
Well, these matters have taken some time, my Lord.
Yes.
We'll take them next week, my Lord.
Next week?
Tuesday or Wednesday.
Covered matter, no?
Covered matter, but we have gone to Supreme Court, my Lord. The matter is still pending.
Previously pending writ appeal also cleared by the division bench.
Yes.
In fact, pending writ appeal also disposed of in favor of the my lord present petitioners.
We have after 1 week, Mr. Chanda.
My lord, can it be after 2 weeks, my lord?
This is a matter, the request of Dr. M. Hoskan digital is a matter after 1 week. Yes. Yes.
Item 30.
So appearing for the appellant.
Yes.
I've already filed a brief note on the evidence, but the other side
Where's the other side?
they've not been appearing, Your Lordship.
Why? Who's the other side?
Mr. C has been appearing on
Because last time
several.
the respondent they mention was made that case Kharshi. You sure?
Yes, Your Lordship.
No problem. They appeared, case Kharshi has been appearing regularly. Only on one date, only 2 days. 13/11 didn't appear, and on 24/11 they took time.
Yes.
You don't know them. You know them, right?
I know them.
As counsels, as brother counsels should inform them.
I've already informed him the last date because he was on call.
No, I mean, what today's date?
I'm not sure that's the.
Mr. A.R. Prasad submits that a brief known evidence already been filed. However, today none has appeared on behalf of the respondents. Is expected on next date. If no appearance is made on the next date by the respondent, matters to be taken up in their absence. It is up to week, yes.
Obliged.
Item 41.
Right, Your Lordship. My lord, this is relating to that Weybridge. My lord, there is a connected matter also. Now, what happened in this case, my lord? This was due to expire on September 25th, next year. Now, before that, they have issued an order, and this is for 1 year, and supposed to expire, my lord.
We understand now what happened.
Now, Your Lordship, what happened? During the pendency, interim order was extended. Lordship has granted the interim order extended till 29th of last month. Now, before that, Your Lordship, during the vacation, they had issued an order recalling that impugned order which was under challenge. So virtually it has become infructuous, but at the same time they had withdrawn the enforcement stuff. So I moved that petition on the last working day, Your Lordships, and Lordship has posted it on 13th for instruction. So, my lord, though it otherwise become infructuous, this will have some bearing, my lord, otherwise. So it may be posted on 13th, Your Lordships. Because it may, yeah.
Nothing left, my lord, in this case.
Whatever, my lord, it's there, Lordship.
Yes.
Yes, Mr.
13.
Learned Counsel for the petition submits that due to other developments, the fresh petition being WBC number, the fresh one is number? No. Number 8 of 2024 has been filed. He prays that this matter be listed together
on 13th.
On 13th with WBC number 8 of, this is yours?
Yes, ma'am.
Of 2020, yes. Now, if enforcement has been now, collection is stopped.
Exactly, my lord. They deliberately. One hand, they have withdrawn the impugned order, pursuant to the court's order. And the other hand, they have taken.
From other information, we believe that enforcement personnel don't do any. Is the